Welcome, dear participants, to today's international conference. This topic to be discussed today is very important for all Ukrainian lawyers and judges. As we all know, in 2017, Ukraine signed the association agreement. So in 2017, it wasn't signed, but rather it was fully legally fledged. And according to this agreement, Ukraine undertook an obligation to approximate its legislation to EU law, and this approximation obligations cover not only acts of legal acts of European Union, but as well case law of European Union as well. And as we know, the European Union based on the rule of law principle, and it means that every action of the European Union is based on treaties democratically approved by its members, and laws of the European Union help to reach a number of aims and their ways to apply EU policies in practice. And the rule of law cannot be put in place without independence of courts and judges, and we know that Ukrainian courts apply this European legislation more and more, as well as a key in their decisions and judgments. It's a big challenge. Moreover, European legislation is developing all the time. In our opinion, constant activity, constant work with Ukrainian judges with a view to quality training is very important. And for us, the European Union project, Prava Justice, it's a big honor and a big challenge that we can work together with the Supreme Court, together with the National School of Judges, to improve application of EU law by Ukrainian judges. I hope that today our conference, today and tomorrow, will be very interesting for all our participants. I hope that we already have evidence because we have raised so many questions via correspondence from our participants, a lot of detailed and thorough complicated questions that our speakers will try to answer. Now, I think that Judge Lvov is not yet with us, so welcome remark then will be given to the rector of the National School of Judges of Ukraine, with whom we always effectively cooperate. So, Mykola, the floor is yours. Thank you so much, dear Anna. Good day, dear participants of the conference. Dear guests, and whoever is assembled here at this conference, really, the topic of application of EU law in Ukrainian perspective, it's important. To tell the truth, Ukrainian judges have just started applying and have just started shaping case law or jurisprudence related to EU-Ukraine Association Agreement, and it's of paramount importance to shape some positions and to hold discussions on that regard. As you put it right, Anna, European Union is a recognized interstate institution. It has international legal capacity, and it has all the necessary features of international treaty ratified by the parliament. That is our association agreement that is to be applied and that creates legal consequences for legal entities and for individuals. And these issues are governed by this agreement. The association agreement has already been applied by the Supreme Court and by Cassation Commercial Court and by Cassation Administrative Court. These examples of application are well known. For example, Cassation Commercial Court within the Supreme Court, in considering case, applied Article 145 of the agreement, its capital movement, and Article 198, registration of trademarks in the association agreement. Therefore, the practice of applying association agreement is being formed, and it's very important, and that's what our event will be devoted to today, to in deep detail understand the nuances and peculiarities of applying respectful legal norms. Thus, I want to explain that subject matter of consideration by Cassation Commercial Court had to deal with challenges of actions and omissions by state fiscal authorities as to the fiscal price and the definition of entry of the goods according to respective regimes and applying special safeguards as to dumping and other aspects. That is, jurisprudence evidences that EU-Ukraine Association Agreement is a part of national legislation of Ukraine, and its provisions are of peremptory nature. And it's natural that the Supreme Court holds on to that position, and local and general courts and appeal courts, understand the subject matter of the agreement and its legal framework. At the same time, according to association agreement, Ukraine undertook to adapt gradually, you already said, to approximate EU to approximate Ukrainian legislation to EU standards, and there are cases when a key that is acts by the European Union create legal consequences or are used to some legal relations in Ukrainian courts. The analysis of association agreement provisions provides us with an evidence that we can here specify at least three spheres when it is necessary to apply EU jurisprudence. In particular, it's IP protection, its rules of competition, and procurement. This necessitates studying European law right now, today, despite the fact that Ukraine is not yet a member state. We must unify legal institutes of international law and domestic law. EU law is a very special, as we know, it's supranational system. Today, EU law is a structured system with its own sources of law, procedures of lawmaking, and application. This is beyond doubt, but it is important to emphasize that today we are speaking about a completed legal system, as already mentioned. It's structured and it has all the necessary elements. EU law has direct effect, and in the national legal systems of member states, it's natural and it's provided for in respective sources of law. And direct effect means that not only member states have rights and obligations, but legal entities and individuals as well that can protect their rights guaranteed by EU law via submitting respective claims to member states, that is, within domestic legal system and directly to EU court. And this provision that ensues from Lisbon Treaty and is very well understandable. But what is important that it can be adapted to association relations of Ukraine with the European Union as to issues where Ukraine undertook to do some steps, and respectively, the right to protection arises not only for a member state, but for legal entities and individuals of Ukraine as well, and relations with the state of Ukraine and with the EU. As it is very well known, Today, European Union creates respective legal order and international law when states limited their sovereign rights, but also they have the individuals have the rights. So that is my reiteration of the point that I have made. In a number of cases considered by ECJ, it was mentioned that unlike usual international treaties, the EC Communities Treaty established a legal system of its own, and it made sure that courts must meet these rules. At the same time, we must identify and understand that in our conference today we lack special knowledge as to EU law. And this international conference will contribute to getting new knowledge and skills in this field. The National School of Judges, within the framework of cooperation with the Supreme Court and international projects, is drafting a course training courses on EU law with inclusion of renowned international experts and national judges. And such conference that is being held today will also be useful to make sure that those who draft these courses, their participants and trainers, better master the topic of these training courses using the knowledge and comments that will be heard today from our participants.
I'm very grateful for your attention and I wish you all good luck and a very productive conference today and tomorrow. Thank you, Mr. Mikola, for such a heartful welcome speech. Thank you for all your support you provide to the cooperation relations between the project and the National School of Judges. And now I'm very pleased to give floor to Bogdan Lvov, President of the Cassation Commercial Court of Ukraine under the Supreme Court of Ukraine. Mr. Lvov, the floor is yours. Thank you, Anna. I'm an example of a judge who is not very good with modern technologies, even though I'm very good in codes and legislation. That's why I'm late. The topic of our today's conference is extremely important and can hardly be overestimated. The EU law and today's conference are supposed to close the gaps which exist today in the legal education in Ukraine. I'm taking this opportunity to express my gratitude to Anna Adamska-Galant, who is acting on behalf of the Private Justice Project. And I hope that such conferences and trainings and events which we organize together with the project would allow us to not only quote and make analysis of EU legislation, but also to apply European acts when administering justice. I wish everybody good cooperation and vivid spirit of collaboration today and tomorrow. Wish you all good luck and thank you. Thank you, Mr. Lvov. Thank you for your kind words. As Mr. Onishuk and Mr. Lvov have already mentioned, we are currently working on the development of a training course for Ukrainian judges. The course is dedicated to proper application of European law. The application of European law is a very topical issue for EU member states, especially for those which are located in Central Europe, who are relatively recent members of the European family. That is why we will focus later on, namely tomorrow, on the experience of Poland and Hungary, while today we'll give floor to Ukrainian judges, and at the end of this day, we will have a speaker from Great Britain. And now I'm given floor and moderation powers to Rasim Babanli, our great long-term friend. Rasim, please, the floor is yours. Thank you, Anna. Dear participants who pronounced welcome speeches, I'm grateful for your kind words. Let me mention at the very beginning that the conference we are holding today is a second conference in a series of events organized by the Supreme Court and the National School of Judges in cooperation with Ukrainian donors. The first conference has already been dedicated to the analysis of practical application of European law and the possibilities of such application in Ukrainian courts. Our present conference will be composed of two sections split between two days, today and tomorrow. At the previous conference, we discussed more general and theoretical issues of the EU law application in Ukraine, while this conference is expected to be more practical, and we hope that we will have a chance to discuss some details which are crucial for proper application of EU law in Ukraine. After having held the first conference, we realized that the EU law is all in all designed to protect at the highest level possible human rights. And this is something which is very important and very topical for Ukraine. I'm very pleased that to have today prominent and well-known experts in EU law and international law for human rights. I believe that your expertise will be of great value for all the participants on for Ukrainian jurisprudence. I'm now inviting Mr. Mikhailo Makievich, head of Department of International Law of Lviv University, and he will make a presentation dedicated to the architecture of the EU law and its incorporation into Ukrainian legislation. Let me say that in chat and on Facebook, we are already having a lot of questions from the participants, so we will alter presentations and Q&A sessions. Thank you, dear moderator, dear colleagues, Mr. Onishuk, Mr. Lvov, Mrs. Anna Adamska-Galant. I'm very pleased to be invited to participate in this conference. As of today, the Proper Justice project has already implemented multiple initiatives, both in Kyiv and in the regions, which are um, targeted to the reform of the justice system in Ukraine. Thanks to the Proper Justice project, we have access to international expertise delivered by prominent and widely known international experts. It's also a chance to share knowledge and best practices. Even today's event is bringing together prominent experts in EU law. I'm talking about such personalities as Ksenia Smirnova, a representative of Kyiv School of European Law, Professor Komarova, who has been majoring during all her professional career in the case law of the Court of the European Union. The event is co-organized by the Supreme Court of Ukraine, and it is also something worth mentioning because the Supreme Court as a highest court instance in Ukraine is supposed to ensure approximation and implementation of European law to Ukrainian legislation. As of today, I can state the situation in the Supreme Court has much improved over the recent years. Currently, the Supreme Court of Ukraine is composed of mostly of a young generation of judges who are well who know well European law and who are well aware of the way European case law can and must be implemented in Ukraine. There are so many decisions, including modern decisions, issued by the Court of the European Union. And these judgments are so good that they worth to be taken as a model and in general be taken in consideration, not only in EU member states. And it's something which is already happening. For example, in Switzerland, there are final court judgments where judges give reference to European case law. The general architecture of the EU law is directly relating to the legal nature of the European Union. European Union is a unique phenomenon. It was so since the very moment of its creation in Paris up to the moment where the latest um, drafts of EU treaties were signed in Lisbon in 2007. International um, community acknowledges that the revolution of dignity which happened in Ukraine back in 2013, 2014, made Ukraine closer to the European community. The revolution of dignity was caused by the aspiration of Ukrainian people to get closer with the European Union rather than because of their being dissatisfied with high tariffs, consumers' rates, and so on and so forth. So I would want to build up my presentation today through the lens of aspirations and expectations of Ukrainian people after the Revolution of Dignity. So now I'm going down to the core of my presentation. It's important to keep in mind that the EU um, currently mostly adopts regulatory acts which govern the field of economy. However, back in time when the European Union was found, the ultimate goal of joining together and developing joint regulations was to ensure peace in Europe. This is why the example of the European Union is important, so important to Ukraine, which is currently suffering armed conflict in the East. The European Union gives a perfect example of how law and legal system, building a joint legal system, may help overcoming differences, discrepancies, clashes, and ensure peaceful coexistence over a certain territory. And it's a common knowledge that since the establishment of the European Union, there was no armed conflicts in Europe. So the first and ultimate goal of the EU establishment was to ensure peace. Further on, the EU management also focused on such issues as welfare, well-being, increase of level of life, and so on and so forth. Currently, the European Union, well, since the moment it was established, the European Union has been through multiple challenges. Among recent challenges, we may remember the huge waves of immigration and terrorism and problems which are intrinsic to multicultural societies, COVID-19 pandemics, and others. However, the way the European Union gets through such crisis situation proves that the structure of the European Union and integration processes are good and useful for stable existence of a state or an interstate institution as the European Union is. So the obligations envisaged in a constituent treaties of the European Union are mandatory on all member states and as well as legal entities and natural persons um, staying in the member states. Ukraine should take into account such approach and comply with this with these standards. We are putting main focus today on the Court of European Union. Indeed, the Court of the European Union is a unique entity which has a very particular place in the EU legal system. What is characteristic for the European Union is that the EU court often makes a decision which may differ in the down in the core from approaches applied in national courts of EU member states in case if such approaches are inefficient.
And I very much like the statement by our friend, the Professor Adam Lazovsky, who who named his article "The Rule of Law of that is the legal adventure that paid off," and the key judgments, that is, judges in 60s, 70s rendered some milestone judgments that shaped the principles of law, of rule of law, and of the direct effect of the European Union. And we can't even imagine how it was when then EC communities states were disputing over the issue as to whether it is necessary to meet on a regular basis for them. So that is the Council of the EU that started functioning in 1974. EU member states objected to the necessity to meet regularly, so they were afraid to give over some part of their sovereignty at the state level. They were afraid to take such steps, and here the EU law judges take this unique step when they highlighted first direct effect, that is, they decided this public dispute as to whether an individual is a subject to interstate relations, to interstate public law. They decided it is so with legal entities and with individuals. And they decided that this norm that is shaped by the court is half higher hierarchy than that of the national law. And it's very interesting that this issue concerned very minor, at a first glance, issues, some definitions of national standards of trade, etc., etc. But while these simple things, we see the shaping of a position that is prevalent today. And this was an adventure that paid off, as said Professor Lazowski, because at that time there was some apprehension that the court will be no longer an authority and that it will be nothing. But given stability of court, given regular sessions, we see the principle of stability, and that was not somewhere enshrined in constituting acts of primary law, but it was a key point. As to acquis communautaire, what we mentioned today, it is different, but there are different definitions of this concept. But it's my pleasure that today our lawmakers, our the Parliament, the Verkhovna Rada, and judges in a right way understand the content of this principle. It is not only the norms, the written norms, the positive law of European Union. No, a key covers here ideology, values that are of determining nature that helps courts to govern different relations. For example, today there was mentioning of fiscal law, customs relations, and that is important to have the understanding of a different ideology of customs that is that when crossing of the goods is kept and recorded not when it's crossed the border, but later via some economic and bookkeeping mechanisms. It's different ideology of fiscal service, of customs service that helps to dispense with many problems. But as to legal system and the judiciary, it has been through many challenges. And with the permission of our moderators, I will prolong my address for 5 minutes because we started off later. Ukrainian system has been through a lot of challenges, and there were different positions, there were different emphasis made, there were sometimes Euro-Asian integration emphasis, sometimes European, but this Europeanization of the system started off almost immediately when Ukraine joined the Council of Europe, and finally when there was signing of this married document, the EU-Ukraine Association Agreement. And this is the topic of today's conference. We have been speaking about it and we will be speaking about it. I want to emphasize that although as to subject matter, norms of rule of law are of a much less quantity in association agreement, but if we speak about content, these are the key provisions. Starting off with having due legal and judiciary reform, it is the cornerstone of association of effectiveness of EU-Ukraine association agreement. Our judiciary has had a lot of improvements. We have a lot of experience of training judges, and I want to say that our judiciary has been through a very difficult path of implementation of international obligations. That is, starting off with treaties when, from legal and technical perspective, it's the easiest when this international agreement becomes law via ratification, and here application of some challenges do not arise, and via practice, via accession of Ukraine to the legal system of the Council of Europe, we remember that first Ukraine had some challenges when Ukraine undertook too many obligations. After joining, for some time we have been thinking, how shall we deal with it? Because Ukrainian system was not ready, but judges in Ukraine were convinced, I'm convinced that they are professional, they have high integrity, and via this perception of European Union court case law, the first source of law was in our legal system. It was a judgment. It was not easy. There was a period of training. Now, ECTCR case law is our living instrument that is there in Ukraine, and step by step we come to case law of the ECJ to as that non-formal source but bottomless source of application of the norms that are implemented in the association agreement, that are the sources of secondary law. We know that it is also that, and Ukrainian judges do that rightfully, lawfully, and legitimate. They take into account the case law of the Court of European Union, thereby improving the situation of integration. And again, to emphasize, association agreement was not forced upon us. It's our choice. It's the choice of our state. And given that we know that association agreement is of valuation character and next stages are contingent upon performance of some criteria of the previous stages and monitoring of national jurisprudence, national case law is a criteria of assessment whether Ukraine complies with EU standards in all the fields where we have already some petitions, where we have some references. Today, competition law was mentioned and IP law as well. But the general monitoring, the overall monitoring of case law is another important indicator how much Ukraine complies the requirements, how much we can go to the next stages of implementation of the EU-Ukraine Association Agreement. And Ukraine has shown that it is responsible. It is a responsible state, a responsible partner. The signing of the treaty itself on visa-free regime, it required dozens of laws and requirements and bylaws that led to the result that Ukraine can be a partner with which visa-free regime can be done. And at the end of my address, I'd like to mention what should be the cornerstone of application of EU law that is before the courtroom. Judges are law students, and at this stage, it is very important, and we understand that the task of our universities is of paramount importance. We must be cutting edge there. We must be able to prepare students, lawyers to deal with case law already when they are studying, and it's done in the Kiev Institute of International Relations, in Kharkiv Institute, and in Lviv Institute. We introduced the law of European Union. That was our discipline. It's not our just subject, but it's a specialization that students can choose. They covered 12, 14 subjects of EU law, and it has been already 2 years that we introduced discipline, which is called EU case law. Now we are drafting some handbooks in that regard, and to finalize, I'm sure that Ukraine, by joint efforts with the help of our friends and partners that are of huge help to us, I again emphasize my gratitude to EU Private Justice Project and all the colleagues that we have been working. I thank for your support, and I hope that we will continue. I'm convinced that we must meet offline ASAP without Zoom, although Zoom provides us with some, affords us some opportunities, but we lack personal communications. Thank you for your attention. Thank you very much. It was a very interesting presentation, and thank you for the fact that you have many lawyers who are already specialists in EU law, and it's our pleasure that out of EU experts, we have here today joint cooperation. Rasim, thank you, Anna. Thank you, Mikhailo, for such an interesting address. I want to ask you a short question, given that we are now taking first steps in considering EU case law. What is your advice? What a person shall start with? A professional who wants to understand the legal nature of this case law and its importance for Ukraine, what shall be the first step to understand it, to look for it, and to work in that direction? Actually, thank you for your question. It's indeed interesting. First step is to understand, to just understand the difference between judgments. As I tell my postgraduate students, read two theses and then you will understand what a thesis is. And given our cooperation with partners in Bravo Justice and Association for You, we have a lot of materials, a lot of judgments translated to understand how the system works. I would recommend to read a few judgments of the ECJ to understand how responsible and serious judges treat their assessment of the situation when they take decisions, how much serious this issue is. Thank you for your answer. I also see that we have some sources from Tatiana Komarova. She shared her monography, so you can look at it. And sorry, I would like also to recommend to read, to start with Professor Komarova's monography. So it would be, it is unique handbook. I'm sure that this recommendation will be included in the conference. Thank you, Mihailo. Vitaly, we have already heard of Cassation Commercial Court as the application of EU-Ukraine Association Agreement. So now the floor is yours to understand how it takes place in Ukraine. Thank you. I'd first like to thank and welcome all participants and panelists. Thank you for holding it. It's very interesting indeed. And as a judge, I'm very much interested to hear the opinions of academia as to how we should apply the law of EU in force and to share what we already have to understand whether we are moving in the right direction. I have prepared a small presentation on that issues. Now I'm going to share it with you. In this presentation, I will draw your attention to the fact how in the case law of the Cassation Commercial Court, EU law is used, and I will also remind you about association agreement. Many of you may know that Cassation Commercial Court is one of the components of the Supreme Court, together with criminal, administrative, and civil, and it is aimed at governing disputes in commercial cases, and we have more than 40 justices here, and all of them are divided into respective panels. In particular, we have panel on considering bankruptcy cases as to IP protection and also related with competition law, also corporate disputes and securities, and also issues of land disputes and property rights. And it doesn't matter to which panel the justice is included to, we apply in some of our decisions acts of EU and EU-Ukraine Association Agreement. I will tell a few words about the legal acts that I'm speaking. First off, it's a regulation. It must be a SEP enforced by its member state. It can be a directive that is legal act that aim at solving some issues, and this aim must be reached. I will say that within commercial court of EU of Ukraine, we mostly use directives of the European Parliament and of the Council of the EU. And on this slide, you can see that each state that is within the EU by itself chooses in what manner it will implement their obligations into legislation. And these acts do not directly govern the relations, but when we implement directive, it becomes a part of the national legislation. And as to Ukraine, the application of this directive is that we have it and it is very relevant. Then I will show how some specific directives are used. So let's start with Directive 2004-25. It's a proposal of price of merger. Reference to it is included within a special annex to association agreement, and Ukraine undertook to approximate its legislation as to founding and functioning of companies, corporate governance, bookkeeping, and audit. And what you see now on the screen, it has many provisions that govern legal, legally social relations, and Ukraine tries to approximate it to its provisions.
Let me draw particular attention to Article 15 of the above mentioned directive. The Article 15 governs the possibility of the offer to buy securities from securities holders at a reasonable price. As you may see, the EU um, also imposes that the holder of securities, of 90% of securities, may require other shares being sold for a reasonable price. The 90% threshold is minimum. The maximum threshold, which may be decided upon by each country separately, is 95%. Um, Ukraine, while adapting its corporate legislation to EU legislation, introduced such a mechanism as squeeze out and sell out. As to percent held, Ukraine decided to apply a higher threshold of 95%. The references to directly on takeover bids are contained in rulings of the Grand Chamber of the Supreme Court of Ukraine of November 2020 and January 2021. In the above mentioned cases, the claimants required whether the above mentioned provisions and legislative amendments were compliant with the Constitution of Ukraine. I'm giving references to the rulings of the Grand Chamber and reference to the directive on takeover bids was given in order to substantiate better the rulings of the Grand Chamber and to underline that amendments introduced to Ukrainian legislation following the signature of the association agreement are those required for the approximation of Ukrainian legislation to EU law. The next directive I would want to cover in my presentation is Directive 2009/72 on common rules for the internal market of electricity. There are multiple disputes arising around electricity supplies regarding consumer rates, regarding tariffs. I understand that these cases are usually very specific since the adjudicating in such cases requires not only legal knowledge, but understanding of technical peculiarities. However, the above mentioned directive gives some good explanations and guidelines on how the cases need to be tried and facilitates the adjudication process. For example, the directive says directly that in a case of the change of electricity supplier, the consumer is not supposed to pay any fee except for fines which may arise in connection with the early continuation of the previous contract. Another directive, which is Directive 2009/101 on coordination of safeguards, which for the protection of interests of members and third parties are required by member states of companies. So the directive says that in case if a company is represented by a person or a body, and it is envisaged by the statutory documents of such company, then in case of any disputes arising between the company and a potential client, individual or legal entity, such a company cannot claim that the above mentioned representative person or body were not in power to act on behalf of such a company. So the directive in such a way protects the interests of counterparts of respective legal entities. There are rulings of the cassation instance courts containing reference to the Directive 2009/72. And now I will say a few words on how the association agreement applies in the field of intellectual property. On this slide, you may see references to several articles of the association agreement, in particular on Article 158 and 198. The above mentioned articles have direct may have direct effect within Ukrainian legal system. The speakers, which we'll talk later on, might want to focus on the issue of possibility of direct application of certain European rules and articles of the association agreement. However, as far as Article 158 and 198, the Cassation Court of Ukraine has already articulated its position. They may be applied directly. For example, the Cassation Court of Ukraine applied directly Article 198, saying that trademark shall be liable to revocation if within a continuous period of 5 years it has not been put to genuine use. However, the Article 198 is more extensive than that. Thank you so much for your attention. It was my short overview of some European directives which have already been reflected in Ukrainian case law. All in all, I may say to wrap up my intervention, as of today, EU rules mostly are not directly applicable in Ukrainian courts. However, such rules usually contain many interesting ideas that cannot be taken into consideration by Ukrainian judiciary. Thank you, Mr. Orkevich. Thank you for making an overview of the case law of the cassation. The Commercial Court of Ukraine touched upon the issue of direct applicability of certain articles and of the association agreement and European rules. It's a very vast topic which will need to be developed by other speakers. The legal certainty in Ukraine requires European rules to follow some procedure to be implemented, to become part of Ukrainian legislation. Anna, it seems that you want to say something. Yes, I have a very short comment. The fact of reading the case law of the Court of European Union by students is a very effective tool of teaching young lawyers to understand not only the letter but the spirit of European law. It's something that we used to do in Polish university some time ago when I was a student, and it's something which allows understanding the core, the sense, deep sense of legal rules rather than the letter of law. Thank you, Anna. Thank you for such a remark. Mrs. Komarova, you will be the next speaker. So you answered in very details my question which I asked some time ago. You answered to my question in the monography, which was published back in 2010. So what changed since then? Do you believe that legal order in the European Union somehow evolved since then? Has something changed? If there is something new we need to take into account when trying to approximate our legal order to the European one? Thank you for your question, Rasim. I hope everybody can hear me well. Basically, I have a monography which dates of 2019. Unfortunately, it's not publicly accessible yet. In my monography of 2010 is so what I've written there is still actual today. Some of the so what is written in that monography is still valid today, because the association agreement says that Ukraine must implement a series of European legislation. The European Union, as a Ukrainian partner, follows closely the way the principle of rule of law is being respected in Ukraine. The concept of respect of rule of law, which includes human rights, can be clearly seen from the case law of the EU court, and not much things has changed since then. Coming back to the association agreement, some of its articles clearly make it clear that if Ukraine fails to comply with majority of its commitments under the association agreement, the approximation process may be suspended. The areas of approximation include such areas as reform of justice sector, anti-corruption reform, and many others. So if Ukraine does not comply, then the association agreement may be suspended in terms of its economic part. I'm talking about a free trade zone. There are certain criteria which are universal for all EU member states in particular areas. For example, independence of judges. There are common in the European community, there are common criteria of what is meant by internal independence of judges, external independence, and Anna is in the best position to confirm how important it is, considering the current situation in Poland. Now I'm going down to the topic of my presentation. I would want to focus on the mechanism of protection of rights of private persons in the Court of Justice of the European Union with the involvement of Ukrainian element. With the adoption of the association agreement, Ukrainian natural persons and legal entities received the opportunity to protect their rights before the Court of Justice. The association agreement is an unusual treaty because usually treaties are about relations between countries, while the association agreement regulates areas which are more relevant for private persons and legal entities. After the adoption and signing off of the agreement, many Ukrainian companies and entrepreneurs moved to European countries. You may see that in 2019, 36.6% of export of goods and services from Ukraine was destined to the European Union. Unfortunately, in 2020, the situation has deteriorated because of the pandemics. All the above means that Ukrainian businesses seek legal advice on how they may protect themselves if their rights are violated on the territory of the European Union. On this slide, you may see who exactly may seek protection in European court institutions. Speaking about protection of rights, there are several ways. The first one is addressed before the Court of Justice of the European Union, and the second one is taking action before national courts of EUMS. And whatever way one uh, chooses, there are some things that one needs to understand. First of all, these two ways are not anyhow intervened. People often think that the Court of Justice is similar to ECTHR in terms of accessibility. They think that before going to the Court of Justice, they need to um, exhaust all remedies before national courts, which is not true. Basically, the Court of Justice of European Union has been established with the purpose of protection of private interest from actions or omission of European institutions. Uh, Now I will give a short overview of the um, structure of the Court of Justice of the European Union. There are two main components, which are the Court of Justice and the General Court. The delineation of instance of jurisdiction between these two parts of the CGA EU is very particular. There is no vertical jurisdiction. So the Court of Justice accepts lawsuits from member states and institutions of the European Union, while the private person may only take action before the General Court.
Judging from the numbering, you can understand whether it's Court of Justice or General Court because the Court of Justice has case C and the General case K. So you can already decide what it is. So case C and case T. So mostly when we speak about individuals, it will be references to General Court. So what are the possible visions? What are the procedural opportunities for the claimants? First, it means that directly individual acts can be challenged when against a person there is some decision rendered and a private person recognizes it. And coming back to the previous slide, I said that from general court we see individuals claims, but third parties, non-EU member states are also covered by this definition of individuals. And if let's imagine Ukraine sues the EU, it means that it will go to general court. Recently, Venezuela had a similar situation, Venezuela versus European Union. So, direct challenge of EU law, and here we can challenge either addressed to a person or directly or individually concerns this plaintiff. If you look at this procedure and at the grounds for challenging EU institutions acts, you will see that it's 100% administrative procedure. Very frequently we hear that EU court it's sort of hybrid court, so here you can see it's functioning even sometimes as constitutional court. But private persons can challenge EU institutions actions on some basis. So it can be used either individually or cumulatively. First, it's when it's less of authority when either when a material procedural requirement was violated. It's very often used. Claimants often refer to the fact that they did not have the right to protection, they could not enjoy it. A very famous case when Saudi Arabia Qadi sued EU and his assets were frozen within the EU because he sponsored Al Qaeda and he sued to the effect that he wanted to have these assets unfrozen because he wasn't informed of that. And EU court had a challenge. It was between the devil and the deep sea, either human rights or public order. And here the EU court said that there was serious violation of material procedural requirement. It was so it was cancelled. His assets were unfrozen within the EU. For a lawyer, it's a very good trick to play with this ground. Then it's violation of constituent treaties of EU or abuse of powers. It must be mentioned that EU gave very short limitation period, 2 months. It's understandable because it's principle of legal certainty. Because if it were possible to challenge ECJ judgments for a very long time, no one would know the rules of play and it would undermine legal certainty principle. Its first possibility direct challenge of EU acts, and another is that you can challenge a mission when the ECJ had in respect of you to render a decision but didn't. And the same grounds and the same limitation periods are there, but most frequently we see the use of procedural opportunity as the challenge of institutions acts. You can see in 2019 the General Court got 445 cases because in previous year it was almost twice less. And admission, here we had only 14 cases. And here you can compare, dear Supreme Court justices, your workload with the workload of the ECJ, but it's not as easy as it might seem. Let's have a look at direct challenge of institutions. I said that there can be two scenarios. First, one action has to do, not action, decision has to do directly with the plaintiff. He is the addressee, no challenges there. I'm presenting you example with Ukrainian element when in general court there were decisions challenged which regarded Ukrainian individuals. First one is I would call it not a very pleasant stain on Ukrainian reputation. It's Yanukovych versus Council, Azarov, Kluev, etc. These are decisions against seven former officials that are charged with the embezzlement of state property. And why I said not very nice for Ukraine? Because most of these cases here, plaintiffs, they won. Because the decisions had to do with the fact that their assets will be frozen within EU via what I said, embezzlement of state funds. And most of the decisions of the General Court quash the decisions of the Council because there were violations of material procedural requirements for adopting this act. Zarov, Yanukovych, and Kluev approving in the General Court that Ukrainian state did not provide guarantees for fair trial and also referencing to non-completeness of proceedings. And the council, when imposing sanctions, it was based only on the documents of the general prosecutor's office, and unfortunately the parliament did not the council did not substantiate. It did not prove that there were guarantees of procedural rights of these plaintiffs in Ukrainian legal system. That's why, unfortunately, their assets are not assets. Here we have a nice call that sanctions are taken for 6 months, and the lawyers of these persons cancel previous sanctions and new sanctions appear, so assets are all the time frozen, but it's an indicator that we must be more attentive because then it will be considered in Luxembourg. Next case that I can present to you when decision was directed at an individual. It's Russian versus European Union Intellectual Property Agency. Here it was not allowed to get this trademark of this cane chocolates, but it was because there is similar trademark and it's done by Russian Federation that has similar chocolates, and the European Union Intellectual Property Agency says that it can lead to ambiguity among consumers and said that there that should not be allowed. Another case, if an individual wants to challenge a decision not directed at it, but somehow rather has to do with the plaintiff, and here the plaintiff has a lot of things to prove. He must prove that it directly and individually concerns the plaintiff. Running a little bit ahead, I will say that only 40% are successful in proving this individual influence of a legal act that does not concern private individuals. For example, what is direct influence? It means that there is causal link between the act and its influence on the plaintiff and lack of discretion with the body that has to implement this act. But for example, if it's not a direct effect, but it is said that the state must implement it and take some actions, then the influence will not be proved and it cannot be challenged. Individual influence, it's if act influences a person because of his or her characteristics or how it is different from all the other persons that are engaged in the same activity. It's a very difficult case for private individuals, and there are examples of Ukrainian origin. There are positive and negative. So you can have a look at this picture. It's fake news that as if Naftogaz lost the case as to Nord Stream. It's fake news because we didn't lose any claim, but we were uh, we were rejected because we didn't prove individual influence, individual effect. The commission took a decision that allowed to open up Nord Stream capacities because before that they were working had been working 10%, but then it was allowed to have much stronger capacities because it's a big transition territory would not be interested, and then of course it's very much influences. And Ukr became a plaintiff against EU Commission, but we were not able to prove direct effect, direct influence on Naftahas because the Commission's decision was targeted by member state body that it was German service stations, and we had to challenge not EU Commission decision, but the decision of those institutions that distributed it, redistributed it. And of course, we have some good cases. It was a decision of 2008. It's Industrial Union von Donbass versus Commission. It challenged subsidies disbursement. They proved both elements. And coming back to Naftahas, I want to say that we were very much supported by Poland in this position as to challenge of Commission's decision. When we renounced, Poland sued the Commission on the 10th of September 2019. There was a positive conclusion for us. Poland's requirements were met, and the Commission's the decisions as to increasing the capacities of the Nord Stream were cancelled, and now it's not used at full capacity. And Ukraine had a winning situation here. So Poland helped us in this regard. Now I'd like to tell you about second, but second option, how to deal with the interests of individuals in national courts. And there are some tricks for us. Maybe it looks like a trick, but maybe for European countries, this procedure is very widely used. If your rights were violated by an authority, use you in the national court and its procedural law of member states. But there is an option here. In European Union, there is a very nice mechanism for interaction of national courts with the Court of European Union. There was a question: how do national courts of member states with the EU court interact? How do they get decisions? How they understand decisions? And a very cool mechanism that was first drafted in EU. It's called preliminary applications to the courts. When a national court faces a problem that it cannot interpret this is that norm of the league of European law that is necessary for deciding a particular case, this judge can suspend the proceedings and send pre-judicial request to the Court of Justice. It will be interpreted and then it will be sent back to the court, and the national court will renew the proceedings and seeing how this norm is interpreted, how to understand it, it will decide in a fair way this or that case. By the way, the Council of Europe also has included similar position, and that maybe the Supreme Court know that when protocol comes into force, the justices of Supreme Court can send prejudicial requests, preliminary requests to the Council of Europe. And similar situation is as to the European Union. And they take, they initiate the proceedings at the same time in national courts and in EU court, and they understand that it can be rejected, and at the national level they can in some way hint to a court that they can use this preliminary request, and the Court of Justice can do that not only within preliminary procedure but also can cancel this norm. And this is while this is used by some companies. Here I provided for some examples. For example, Rosneft versus Council. It sued, as you see, it's D case and C case. So they sued the General Court and Court of Justice when challenging the decision of the Council. It was also sanctions that had to do with the annexation of Crimea and had to do with the support of some enterprises. And Rosneft was challenging the decision, but they were rejected because they initiated almost the same proceedings in national courts of the Great of Britain, where they were financially serviced in the territory of the European Union. So such concurrent proceedings can work sometimes. So it's possible and it should be known. I will not stop at direct effect because my colleague Ksenia Smirnova will tell you about it. Now I covered segment of protection of individuals' rights within the territory of the EU and how they can do it within Ukraine. This will have to do with the following address. Thank you very much for your attention. Thank you, Tatiana, for such an interesting address. Examples are relevant to Ukraine because having some practical vision, not only theoretical, enables better understanding of the subject matter. And coming to next address, I'd like to draw your attention to our chat. In chat, Mikhail Smakovich sent a link to the decision of the administrative court when it had some comments as to use of the situation, and it delineated between legal nature of EU court ECJ and ECTHR. As it was rightfully mentioned by Tatiana, there is some analogy between 16th protocol and the preliminary request. And of course, these systems have some similarities, maybe some sort of mixture and symbiosis, and it enables the development of law and dissemination to member states. Ksenia, please, now the floor will be yours. And I want to mention that you are very active in chat. You so actively interact with participants, and I'm sure that having such feedback, the participants understand that they are heard and they get as as expert as possible answers. And we have many issues to still to cover, so we are really looking forward to your address. I'm sure that you will meet up our expectations.
Thank you, Racine. Thank you for such wonderful moderation. I hope everybody can hear me well. It's a great pleasure to participate in the conference. Racine, you mentioned our last year meeting at the first conference where we just started discussing all these issues. I can well remember at the intervention of Ilos Valancius, Justice of the European, of the Court of Justice of the European Union. It was so motivating to hear his speech where he called on Ukrainian judges to enhance the implementation of EU case law in Ukrainian courts. Since then, we've noticed a considerable increase in application of EU law. In Ukraine, we're also witnessing greater interest of Ukrainian lawyers in application of EU law in Ukrainian context. And the best proof is a vivid discussion we are now having in chat. I will now make my presentation. I will try to answer some of the questions raised by Vitaly Urkevich, judge of the Cassation Commercial Court of Ukraine. I'm again, I would want to underline how grateful I am for having me here. It's a pleasure and honor to be among my colleagues who are best professionals in their respective areas. And what is even more valuable is having here colleagues from EU member states who have joined the European community relatively recently and who can remember challenges and let me use this word, difficulties they had to overcome on their way to the approximation of their national legislation to EU legislation and application of EU law. I'm also very pleased to see my colleagues from Ukraine who represent three major Ukrainian legal schools, Lviv, Kharkiv, and Kiev. So, speaking about the association agreement between Ukraine and European Union. Well, first of all, I want to tell from the very beginning that I eliminated some parts of my presentation because I counted on Tatiana to cover them. She hasn't done so, so I will mention additionally something which will not appear on this screen. Um, so, the association agreement, Ukraine uh, and European Union, how to apply it, how to analyze it, how to make reference. European rules are not automatically applicable in Ukraine because obviously Ukraine is not part of the European Union yet. However, the association agreement hints on the incorporation of Ukraine in the legal paradigm of the European Union. Let me approach this question from two different angles, European and Ukrainian. In the EU doctrine, there is already a mechanism to for direct application of European rules and the national systems. Some characteristics are also intrinsic to Ukrainian legislation. What is common for EU law and Ukrainian legislation? It is in the first place the principle pacta sunt servanda, which means that international treaties which are and commitments which are binding on a country needs to be respected over national legislation. The EU legislation envisages direct effect of treaties, including constituent treaties, regulations, and even directives if they are not have not been incorporated in national legislation. In the meantime, we will not see a rule which would say directly that a particular rule or bunch of rules are of direct effect. It's the Court of Justice of the European Union which makes a decision, not in respect of each and every rule, of course, but by way of setting up some characteristics that apply to rules to make the rules of direct effect. Currently, in the Court of Justice of European Union, we've heard it from Tatiana's presentation, there is a case law involving Ukrainian element. And it means that legal rules of direct effect are applicable to legal entities and natural persons from third countries if their rights are violated on the territory of the European Union. There is a case, Simutenkov, where the Court of Justice proved that the rule of the agreement on cooperation and partnership signed between the EU and the Russian Federation, which was signed back in early 1990s, is of direct effect. And thus, the claimant is entitled to the same treatment in terms of employment as any citizen of the European Union. Speaking about direct effect of the association agreement, there is no clear answer yet, and if we expect any answer at all to come up, it will be the Court of Justice, which will be in the position to give an answer. So we need to wait for somebody to go before the Court of Justice. If you look at Ukrainian legislation, Article 9 of the Constitution of Ukraine indicates the place of international law of treaties in Ukrainian legal system. However, this article does not indicate directly that international treaties have overrule national legislation if there are clashes between them. However, Ukrainian case law gives the answer, and here I'm referring in the first place to Zentiva case. It's a emblematic case since the judgment in Zentiva case acknowledged for the first time ever the supremacy of international law over national Ukrainian legislation. And the court has not looked at the time of adoption of respective Ukrainian legislation and international legislation association agreement in the case. It just clearly stated that the association agreement overruled the national law. The supremacy of so the establishing the hierarchy between national legislation and international law is a topic for a long-term discussion. There was a draft law which was widely supported by members of parliament and um, academia. However, the draft law has not been passed. There was a draft law on the possibility of direct application of international legislation, and it has not been passed either. Now, if we look at what characteristics shall apply to rule to make such rule directly applicable, have direct effect. In the EU court, there is a test which applies in such cases in order to establish whether the rule should have a direct effect or not. There are certain criteria which have been evolving over time. And in connection with the evolution, the European Court, when adjudicating in new cases, may either um, be based on previous judgments or develop the previous judgments and attribute new interpretation to them. Coming back to the test on whether a rule may have a direct effect. The criteria go as follows. The rule need to be clear and um, um, clear and stable. The rule needs to entail clear individual rights. The rule should be exhaustive and the rule should not be limited with any additional clauses set up by the states. After having passed the test, a rule may be acknowledged as a direct effect rule. The when analyzing treaties to set up whether such treaties may have direct effect or not, we may witness a clear application of the above mentioned criteria. In the Simutenkov case, where a bilateral treaty was analyzed, we can see a clear application of the above mentioned criteria. When it comes to multilateral treaties, the EU court position is slightly different. It adjudicated that if a rule is binding on a state rather than on individuals and legal entities of such state, then the rule cannot be of direct effect. While if the rule envisages some legal consequences for individuals, then this rule is of direct effect. In Ukraine, for the in order to ensure the implementation of the association agreement, multiple legislative amendments were introduced. Many new pieces of legislation were passed. However, the outcome is still leaves much to be desired because when developing legislation, when making amendments to legislation, one should be guided by the ultimate goal rather than by formalism and purely formalistic approach. Approximation of legislation needs to take into account multiple aspects, such as letter and spirit of the association agreement, scope of obligation, commitment, whether it comes to full or partly approximation. It needs to take into account general principles of EU law, such as the principle of the rule of law, of legal certainty, and so on. It needs to take into account the type of source of EU law. So all these aspects which must be taken into account for approximation are interpreted by the Court of Justice of European Union. And this brings us to the conclusion that we can not, but take into account the respective decisions and interpretations provided by the EU court. When it comes to a particular dispute or a particular legal issue where a court needs to decide whether the association agreement is applicable, all these aspects also need to be taken into account. Now we go back to Ukraine and to Article 9 of the Constitution of Ukraine. We've already looked at it, but there are other sources of the law which might be of interest for us in this connection. For example, in 2014, the ruling of the plenary session of the High Specialized Court of Ukraine for civil and criminal cases explained how courts should apply international, should apply treaties which are binding on Ukraine when administering justice. It was a breakthrough, even though it happened in 2014. The ruling of the plenary session demonstrates that judges made analysis of various treaties, bilateral, multilateral, as well as Ukrainian laws and codes. The judges looked at existing legislation and based on everything they researched, they stated in the ruling that international treaties which are binding on Ukraine overrule national legislation in case of discrepancies between two pieces of regulation. It also contains explanation of regarding which treaties may be applied directly. So you may see the quote on the screen. The plenary session goes even further and state that the treaties which enshrine human rights and fundamental freedoms are definitely of direct effect. It's something which makes the such rules closer to judgment of the European Court of Human Rights and application of ICTR judgments in Ukraine. On this slide, you may see a question at the bottom of the page.
So this question is to everyone assembled here. The following wording in a protection of their rights, natural individuals and legal entities can refer to those provisions of the AA that grant to them clear and non-ambiguous rights and obligations and do not require additional acts of implementation. What is my question? The question, do we need such wording in Ukrainian legislation to empower courts to check the norms according to their direct effect? Or is it enough, or do the judges have enough courage without existing of such legal norm of the law, to go directly by themselves to test the norms and whether there is direct effect there or not. I maybe will leave this question open now. And of course, the next component of my address will be related to practical ones. We saw reference to information letter of 2014 that also explains to us that decisions of the ECJ cannot be considered as a source of law, but they can be taken into account as additional argumentation. To strengthen this argumentation for harmonious interpretation of national legislation. And analysis of association agreement test that is undertaken by academia representatives, and I, of course, we can look very thoroughly at this test now without any question or any dispute or any case, but we can look at the text of the agreement and decide whether there is somewhere such articles potential that meet the test of a EU court. When I asked myself this question as a scientist, I came to the following conclusion. Yes, such articles are there. Quite easy. For example, Article 17, treating of employees, that is not non-discrimination. Similar norm was recognized as direct effect norm in the Court of European Union. And the article that provides access to administrative authorities, if let's imagine there is a dispute over that, it's direct granting to persons the right that do not require implementation. Article 90, 198 and 98 as to this temporary presence of naturals with a view to economic activity. They are very specific with no references to the need of their implementation. Article 110, it's preventing monopolizing of post and delivery services. It's quite clearly set out, and of course, a separate unit that has to do with IP. And we mentioned case of Zentiva case. All articles, not only 198, all articles in IP chapter are written in a manner that they can be potentially compatible with direct effect test. This is only some selections of examples, but this list can be continued. Moreover, we can determine that even in the existing case law, there are powers on the part of judges to apply a treaty when it is inconsistent with the national law. But in such context, the court can use interpretation acts when applying such international law norms. The Ntiva case, I already mentioned, it's special. It's my greatest pleasure to see here among participants, and my greatest honor to Bogdan Lvov, who was the judge rendering this decision. It is a very courageous decision, and indeed, this decision, inter alia, is now very well known in among European experts, and I've seen many scientific articles published by our colleagues from Poland, Germany, the Netherlands. I saw a separate article devoted to the Ntiva case, Ukrainian case. And in fact, that defined this priority. Vitaly asked, was there direct effect in this norm? I'd rather say that court did not have the issue to check the direct effect in this case. Here, the court said that this norm should be used because there was a conflict of the norms. And so far, I cannot yet name examples in which courts would decide as to testing the norm whether it possesses direct effect. It will depend on case law and jurisprudence. And the jurisprudence says that courts of all jurisdictions start giving numerous references to association agreement and to acquis, the overall law. You can see some examples here. You can look them up in the register to look how the argumentation was set out. It's only the brightest ones. They are far from being exhaustive because such a list is huge. This is indicative one. Among these examples, I'd like to point out some of them. First one, the Circuit Administrative Court of Kiev in 2018. This one, case number 3 on this page. He had a question as to adoption of a bylaw that was adopted based on the law of Ukraine on the natural gas market. And this decision In this decision, it was indicated that authorities and courts take into account application of laws and, in particular, judgments of EU court and the case law of the European Commission. And there is also reference to the case law of energy community, but we know that a lot of them come from there. Another interesting case by Commercial Court of Kiev. It defined reference to Article of Association Agreement that had to deal with competition and it necessitated the inclusion of exclusive supply treaty or exclusive distribution treaty contract. There was no such thing, but association agreement contained references to regulations that had to be implemented, and this regulation covered those notions of exclusive supply contract and exclusive distribution contract. I'll come back to previous slides, and the third case I'd like separately to mention. It's the decision adopted by Cassation Administrative Court in 2020. It had to do with state aid. It was about illegality or incompatibility of state aid and the necessity to recover the money from a transport company to local council, to the municipality. This decision was challenged for 2 years in different instances, and then the Supreme Court confirmed that in using, especially in state aid, the use as a source of interpretation of a constituting treaty of the European Union and respective case law, commission, and separately ECJ, because in this case there is reference to Altmark case by the ECJ that set out criteria for state aid within the field of services of general economic interest. And thereby, Supreme Court reiterated that this reference is done correctly, substantiated, and there were grounds for it. And you can read it in the court's decision. Again, I fully agree that there are spheres where ECG case law can be used. It's intellectual property, competition, state aid, and procurement. Those are cases and fears in such norms. There are some possibilities to give reference to that. Here are those articles. You can see examples 256, 264. It's set out directly. And if we a little bit deviate from the use of direct references to association agreement, we can come to conclusion that it doesn't have to be limited only to those four fields, because then you can check, say, direct effect of some norms, other articles as well, other norms in other articles. So we are speaking about such notion as usation. We say about taking on the spirit and common values. On the one hand, we speak about the transposition of legal structures, but on the other hand, we see that they are being that they are inundating this. And here, quite interesting, it is that at the end of 2020, there was a very interesting monography published by judge of Supreme Court of Cassation Administrative Court, Balesa Radyszewska. She wrote a scientific paper that is named Usation of Administrative Law of Ukraine. And this research paper covers possibility of spreading of such usation issues to relations between authorities, at least as regards administrative jurisdiction. There are a lot of questions to answer. Now we speak how much courageous judges are. Thank you for your attention. We'll be happy to answer questions. Thank you, Ksenia, for such an address. Can you please stop sharing your screen? Thank you. Now, today in chat, we have a question, and I'd like to come back to it and ask it to Tatiana Komarova and Ksenia Smirnova, although you covered it in your addresses, but we would be grateful for some emphasis. One of the conference participants says, what is your opinion as to reference to ECJ case law, given that Ukraine is not a member state? And we discussed it. B, Ukraine sometimes only selectively has decisions in Ukrainian, and C, in some fields, ECJ judgments are very much criticized in the sphere of intellectual property. What is your opinion, Ksenia? Shall we refer or shall we use approach? And the question of language, it's also important because some formulations, they can be in English. There is a word treaty that the wrong translation of one term can change the position and can lead to wrong teleological understanding of the judgment. So, what is your opinion? It's a very difficult, very important question. I'll try to divide it into two parts and share my subjective position on it. Of course, reference to ECJ is possessed by Ukrainian judges. They can refer to it. We can see it from information letter that we have seen. And again, we can see it in case law, for example, interpretation of foreign law, clarifications. And in my opinion, we must understand that Ukraine is not a member state. For sure, case law of ECJ does not cover and does not have the status of origin of law, unlike the decisions of the ECTHR according to a separate law of Ukraine. And this also must be borne in mind. And therefore, legal positions of ECJ can be used only as strengthening of argumentation to make the case stronger. Language issue. You know, even if there is case law, translation into Ukrainian we will not see in the coming decade. A lot of issues has been raised about official decisions of the ECTHR. There was this issue. And by the way, sometimes it is still raised.
Especially if uh, judges seek making reference to judgments which were issued not in respect of Ukraine but in respect of other countries. I think that the next speaker, Pablo Pushkar, will have something to share with us in this uh, connection. Uh, do we need the um, Court of Justice case law uh, be translated into Ukrainian? The answer is yes, for sure, but it's a matter of time, of long time. Occasionally, Ukrainian translations pop up, but these are not official translations. There are some translations of judgments on intellectual property. The association agreement uh, gives says that um, Ukrainian courts may refer to the Court of Justice case law when adjudicating in national cases. Um, However, um, it does not suggest any clear mechanism. Thank you for such exhaustive comments on each of the questions. Tatiana, you may want to add something. I have nothing to add up to what Ksenia said because it was indeed a very exhaustive question. She's very um, objective. It's not reasonable to force judges to make a reference to the case law of the European Court of Justice because we are now facing a situation where judges make reference to the ECHR judgments, but unfortunately 60% of such references are just irrelevant. That is why we do not want to open another Pandora box. Um, uh, However, I believe that the association agreement uh, contains some articles which may serve as a reference for Ukrainian jurisprudence. Uh, One um, thing I what to mention in connection with what you, Ksenia, said. Um, you said that there was a, threat of um, uh, uh, abuse of rights envisaged by the association agreement if Ukrainian element, in particular Ukrainian individuals, address before European courts. However, the association agreement between the European Union and Ukraine is quite restrictive and does not envisage any enhancement of rights for Ukrainian citizens in comparison to European citizens. Besides, there were situations where um, the Commission of the European Union would um, not acknowledge the direct effect of certain um, rules in contradiction to what the European Court of Justice decided, because the European Commission speaks on behalf of all members of the European Union. The association agreement was signed by all the member states, while the position and the statements of the European Court of Justice is just one institution, and its position can not have um, higher significance than the position of the whole European community. Today we are talking much about doctrine and about how doctrine in the developed in the context of the association agreement. Tatiana, I agree that the decision of the European Commission provoked much questions at first. But by the way, I'm an author of an article dedicated to direct application of treaties in the EU case law. So what I found out, the Council has made such has introduced such a clause in respect of other treaties. Um, for example, in respect of a treaty with Korea and other countries. So it's not something unique which happened to the association agreement between the EU and Ukraine. I don't know the reason for implementing such clauses. Maybe it may be explained by the Semutenkov case. However, the Council is not in a power to limit the effect of a treaty. Only European Court of Justice of the European Union may limit the application of a treaty, and the position of the court may be found out only if a respective case is initiated before. Rasimi, would you want to add something to the comments of our experts or not? If not, then we can give a floor to Pablo Pushkar, who is also a speaker at our conference. Pablo, the floor is yours. Good afternoon. Thank you for having me here. Thank you for inviting me. It is indeed a very interesting discussion, and I agree with what Ksenia and Tatiana said about the possibility of making references to case law of the Court of Justice of EU and the European Court of Human Rights. I've prepared a presentation which I would want to share with you now. I hope I will have the equal um, time slot of 20 to 25 minutes as my colleagues who spoke previously. My name is Pavlo Puskar. I am representing the Department for the Execution of Judgments of the European Court of Human Rights. That is why in my discussion, I would also cover the ECTHR case law application as well as uh, the what relations has been established so far between case law of both courts of justice and ECDHR. Today, I would want to touch upon several major issues, which are acquis communautaire on human rights and its role in international policy of the EU. Second aspect goes as follows: problematics of the association agreement implementation in terms of rule of law and justice. And the third aspect I will focus on is the state of play with the implementation of the ECTHR judgments on systemic problems. I will provide you with some recent statistics in the area. And the last but not the least, which I would like to discuss today, is the role of judicial practice and benchmarks of judicial practice and strategic goal. Speaking about acquis communautaire in the area of human rights protection. This topic was discussed for the first time in Ukraine several years ago at a conference in Kiev Mahila Academy. This question is still pending, and there is still not there's still no final answer on how the how acquis communautaire corresponds with ECTHR case law. So acquis communautaire is it is embrace all acts and regulations issued by the European Union over the time of its existence, and naturally it has some part of it dedicated to the protection of human rights. The convention is the convention, European Convention on Human Rights, is considered to be part of acquis communautaire and corresponds directly with the Charter on Fundamental Rights of the European Union. We may state differences in approaches of the Court of Justice and the ECTHR to human rights issues. The Cadi case has been mentioned today, so I will not go into very much details. Here we may talk about different methods of control applied by both courts. The European Court applies so-called external control over the respect of human rights, while the Court of Justice of the European Union exercise internal control, which is envisaged in the Charter on Fundamental Rights of the EU. Experts in human rights say that the ECTHR tend to say that ECTHR serves as a constitutional court of the European Union on the matters relating to human rights. The rules of the Charter on Fundamental Rights covering human rights protection considered to be a shadow of EU rules, other EU rules on protection of human rights. The implementation of the Charter is very much decentralized, meaning that each EU member state decides on the scope of implementation of the Charter on its own. The same applies to the extent of control exercised by such states in respect of the compliance with the Charter of Fundamental Freedoms. Some of the judgments of ECTHR and CJ EU are considered to be emblematic as they display differences in approaches applied by two courts. It doesn't mean that these approaches are completely different. There are a lot of similarities, especially in the meaning of Article 6 of the Treaty on European Union and Article 53 of the Charter on Fundamental Freedoms. We may talk here about minimum requirements to the protection of human rights as envisaged by the European Convention, which correlates with Article 13 of the Convention and some articles of the Charter on Fundamental Freedoms. All these articles provides for effective protection of human rights. However, if we compare the convention and the charter, we may see that the charter contains a wider list of human rights compared to the convention, while the list of human rights which are protected under the in the framework of ECTHR is enhanced by through the ECTHR case law. Talking about rules on human rights protection, which are contained in the European Convention on Human Rights, they may be perceived as part of the general principles of the EU law or as a part of the customer international law. And finally, the last point, which is crucial for the presentation, goes as follows. Human rights and requirements to administration of justice are become more and more often part of external requirements put forward by the European Union in the framework of its external policy, and non-compliance with non-respect of such rights and rules may entail sanctioning for third parties.
Now, another important point from the standpoint of interaction between the Council of Europe and the European Union, this segment has to do with joining, acceding by the EU to the ECHR and recognition of the jurisdiction of the ECHR as to the European Union. And at the end of 2020, there was another round of negotiations between the Council of Europe and the European Union. Our Department of Enforcement of its CTHR decisions was also invited to next round of negotiations as to accession. The idea remains the only one idea. This is an idea to provide a unified constitutional framework with concurrent and synchronized approaches to such protection. As to the second segment of my address, first one was quite voluminous. I tried within the framework of short time frame, tried to introduce it. I think there are a lot of things to say, a lot more things to say as to relations between the EU and the Council of Europe, and also as to the legal relations interaction between ECHR and Charter of Fundamental Rights, between the work of the ECTHR and the ECJ. And the fact that they influence each other, cross-cutting influence. But given the short time frame, I'd like to say about implementation of association agreement between Ukraine and EU, and there are some factual moments that I'd like to draw your attention to. There is such document called Joint Staff Working Document as to implementation of association agreement. As of November 2020, and here we see that first National Human Rights Plan adopted in 2015 exhausted itself, and there is a need to adopt a new one. As to protection of human rights, there are problems, many problems related to media reform, freedom of expression, freedom of word and expression, anti-corruption reform, reform of prosecution and State Bureau of Investigation, state sector of economy, land reform, etc. And they have to do something with the check how they are implemented within the Committee of Ministers of the COE. And there are some new aspects that have to do with references to activities of the Council of Europe, in particular the Venice Commission recommendations as to judiciary reform, numerous references to documents of European Court of Justice in particular. Here we see direct participation of the European Union without the right to vote, so far without the chance to join, but it will be necessary via accession. There is a website, Pulse of association agreement, and it's mentioned that as regards justice, we see in 2020 85% was enforced. It's not understandable what indicators, in fact, were performed, but it looks like these indicators are based on, say, establishment of institutions that must carry out some functions within human rights protection, State Bureau of Investigation establishment as independent body that considers issues of tortures, undue treatment by law enforcement officers that was provided for in particular by in the purpose of this institution creation, and this is indicated as an achievement and compliance with association agreement requirements without thorough assessment of influence. And it's interesting that enforcement of ECTHR, given Euro integration strength of Ukrainian authorities, we see not in documents of the EU. Sometimes it is mentioned in EU instruments, but mostly in the Action Plan Ukraine NATO. It's part of Action Plan Ukraine NATO, and it has to do with making enforcement more effective as part of obligations of Ukraine before NATO. And in 2021, for association agreement from the standpoint of rule of law segment and justice segment, it will be key as to evaluation of the situation with human rights. It was mentioned during summit of EU in October 2020, where it was mentioned that reforms are required in sector that has to do with human rights, rule of law and justice, and it's also mentioned in the last G7 statements as to the need to speed up reforming of these sectors of state activity in January 2021. Why I mentioned G7 here? Because two key countries that participate in G7, Germany and France, are parts of G7, and Germany now is presidency in the Council of Europe committee ministers and in the EU. And as to enforcement of ECHR and decisions, here we say about the necessity to synchronize. A lot has been said on that, in particular this week in the address Didier Renders, representative of European Commission, dealing with the synchronization of activities of the European Union and the COE as to justice and the rule of law. And it was mentioned that it's necessary to join the European Union to ECHR and to European Social Charter that are considered to be key agreements at the European continent, and it is necessary to form unified legal space. So here the overall situation of enforcement of ECTHR decisions, these are contingent upon non-enforcement of these sync requirements of EU and COE as to forming unified constitutional space for ensuring human rights, and they also have to do with ECHR requirements as well. Here we can say about some key systemic and complex issues that have been raised on numerous occasions. It's Burmich case, also Nevmerzhitsky-Sukhachev case that shows no progress on penitentiary, and Zelenchuk and Tsitsura, key trends where we can speak about lack of serious systemic and structural changes, and these are the facts confirming that a lot has to be done to, as far as possible, approximate to overall European constitutional standards of observing human rights that exist in EU law and in the Council of Europe. We can say that in these issues we have about 60 difficult legal challenges. Now we have 556 decisions by ECTHR and 32 new ones to be enforced, with overall number as of 1997 it's 1633 decisions overall. 1633. And overall dynamics of cases to be enforced are quite different. It's access to justice, judiciary reform, criminal justice, penitentiary reform, media reform, and freedom of word, land reform. These are very, very similar challenges considered within association agreement, and it's so relevant that the European Union will also have a look at activities of monitoring bodies within the COE and the activity of the ECTHR as facts to comply with association agreement in this regard. Why is it so? Because the same happened with all countries of the COE that has been through accession to EU or that were in such systemic long interaction with the European Union. Association agreement is very non-typical from the standpoint of history of interaction of the Council of Europe and the European Union. So these instruments that will look at synchronization, I guess they are still to be drafted, but the development that has taken place in the EU as to the system for control of observance of rule of law. Today we mentioned Poland and Romania and Hungary and Bulgaria. These are very interesting segments of how European Union unites its work with the work of the Council of Europe in part of monitoring and observing of human rights. And again, it's reiterated by the Parliamentary Assembly of Council of Europe decision that was adopted this Wednesday. And here we see decisions that have to do um, with Sedic and Finci versus ECTHR. It is joint topic for work for the European Union and for the Council of Europe in context of Committee of Ministers functioning as well. I'd like to show a little bit facts, dynamics of how cases are finalized by final resolutions of the Committee of Ministers of the Council of Europe. It states that in 2020 we see huge decrease in finalization of proceedings in the Council of Europe. And here it's quite clear it's related to the fact that we don't deal with main systemic problems for a very long time 5, 10, 20 years. And I guess this tendency can still persist, given that we heard the following statistics in respect of Ukraine today. It's 10,400 cases. We are reversed. We come back to situation of ECTHR consideration before Burmich case was resolved. That has been that had been considered before. It's about 1100 claims, and we can see that this dynamics can persist because substantiated claims, as you can see, that are being considered in the ECTHR, the claims that can be considered by the Grand Chamber, by chambers and committees, It's about 890 cases, and out of 10,400 and of the cases registered as substantiated and subject to consideration is different very much, as you can see from the chart I presented. On the left, you see how much is different from finalized proceedings and decisions rendered by the ECTHR. Respectively, we can speak about some key issues, and I guess one of the key challenges is how, from the standpoint of the convention and of the enforcement of judgments and association agreement, because they are interconnected, these aspects. It's forming compliance gaps, and we can creatively call non-compliance bubbles. When international law is not complied with, that has to do with human rights protection that is provided for by the ECHR and requirements of the association agreement that, in fact, um, have a bearing on relations with the EU. And these gaps or non-compliance bubbles, unfortunately, only deteriorate with the developments. And comparing to a snowball, this snowball is growing bigger and bigger. How much can these bubbles be filled with case law? The issue is being discussed today. And I guess that such synchronization is possible. It's possible given some criteria, and these are the criteria related to perspective of development of case law and its strategic perspective. We can speak about the meaning of the judgments themselves of the ECHR, the meaning of ECJ judgments in perspective. And here we can speak about presence of some doctrinal principles of European law that are related to the legal system of the EU and the legal system of the ECHR. So we can speak about such principles and principles of systemic and teleological interpretation that was mentioned today. The interpretation of Ukrainian legal norms with a view to harmonize effects of interpretation with a view to make sure that EU law and ECHR is complied with. Here we can say about references to ECJ directly, but I don't see any challenges and any problems why a judge of Constitutional Court or Supreme Court can't make references to ECJ with such a perspective to ensure doctrinal principles and such as Orientierungswirkung and such enlargement, such spreading to non-defined number of cases via erga omnes principle. Another point that has to be mentioned, to some extent we consider EU law as a law that we mentioned it today that have to do with private relations. I guess that principle set forth in the ECHR itself and in the ECJ case law, such drawn doctrinal Dritting Wirkung effect, it's sharing common and homogeneous principles of EU and co-E of as to private legal relations can be a direction to develop case law that can be used in national legal system. In a similar manner, I deem it necessary to mention ECTHR case law as to acquis communautaire, and this is the approach formed in Bosphorus case and the Botins versus Latvia case, where we see presumption in favor of compliance of EU standards with ECHR. That is, this presumption is a very important element of this doctrinal discourse and possible strategic case law development in Ukraine. Another interesting moment that can be further discussed is a point related to requirements to establish means to protect. There is some potential via case law, via jurisprudence. There are some limitations. Here we can speak whether we can make a means to for protection only within Ukrainian legal system, or we do need to adopt laws that will develop legal system, or can we speak about autonomy of case law in this regard? But it's also a very interesting segment that can be discussed in context of such doctrinal milestones I mentioned. And to finalize, a few conclusions. First off, the first conclusion that I'd like to make is that consideration of challenges of compliance gaps, that is, gaps in meeting the convention and the association agreement via such external foreign policy aspect has some potential via case law.
I also believe that if Ukrainian jurisdiction got reoriented towards European case law, then we may talk and expect a more effective protection of violated rights. Uh, Case law of both ECTHR and ASJ-EU influence each other, and the ultimate goal of this dialogue is to enhance and strengthen the measures of protection of human rights. I've recently published an article dedicated to the correlation between the case law of ECTHR and the Court of Justice of the European Union. In the same article, I underline what negative consequences may be entailed by non-compliance with the ECTHR judgments, especially in respect of systemic and structural problems. Which brings us to another conclusion, which goes as follows. The failure to comply with judgments of ECTHR may hinder or slow down real transformation of the Ukrainian legal system and its approximation to EU law. Another conclusion is directly related to Burmich versus Ukraine case, which entailed Ukraine's non-compliance with several directives of European Union in respect of mutual recognition and execution of court judgments. And last but not the least, I have a rhetoric question there. What should go first, economics or law slash rule of law? Even though I said that the question is rhetorical, I'll still give my answer to the question. I believe that law and in a more strict sense, respect of human rights and rule of law should prevail over economic interest, because in the end of the day, the compliance with the requirements of a legal system may bring economic prosperity and may give us expectation to join the EU family one day. there's an example of recent EU members such as Bulgaria, Croatia, and Hungary. They managed to set up good priorities which allowed them to join the EU at some moment in time in the past. Thank you. Thank you, Mr. Pushkar, for your very interesting presentation, for a very detailed development on various issues, and especially for your last rhetoric question. I cannot but mention that currently the European Union is seeking the setup of a joint constitutional system, which would be common for all EU member states, and the situation is in Poland is not the last prerequisite which contributes to this process. All in all, thank you for your intervention. I think we will need another conference to discuss this issue in more details. And now I'm very pleased to give a floor to Professor Erika Shishak, our first international speaker today. Professor Shishak represents University of Sussex. She's a trainer on EU law and former advisor to the European Commission. She has many other roles as well, but what's more important, Professor Shishak will also contribute to the development of a training course for Ukrainian judges. And now I'm very pleased to finally give floor to Erika Shishak. Please go to Ukrainian channel, those who need it.
Very much for inviting me to address the seminar on the role of Ukrainian judges and how they interpret and implement EU law. Of course, I wish I could be in beautiful Kiev today. I also cannot ignore the irony of asking an English lawyer from a third state to now talk about the experience of applying EU law in Ukraine. But my whole academic career has been bookended by the European Union. I was the first generation of students to study EU law as a separate subject at university. And I gave my very last lecture on the day the United Kingdom gave the notice to quit the EU under Article 50 of the TEU. I have been involved in the training of judges since 1995, when Sweden and Finland first joined the European Union. And in 2004, with the very big enlargement of the European Union, I was very involved in the training of judges, civil servants, and lawyers, especially in Poland. More recently, I've been very active in the European Judicial Training Network. And this network provides training courses for judges from all over Europe. And these judges vary from judges in the Supreme Court to judges of the very first instance, and even judges in training. And it is therefore from this experience that I am making my ideas today. I know that Ukraine has observer status of the European Judicial Training Network, and I hope very much that more funding will be available in the future so that judges can actively participate in the network. The website of the EJTN, it is very useful. It has a repository, for example, of leading cases. It has a lot of shared experiences, as well as training handbooks. So I hope very much very soon that Ukraine will be able to be a full member of this network and actively participate. In 2016, I researched and co-wrote a report for the European Commission. And this was a study on national judges' training needs. And it looked at the field of competition law, but I believe that it has a very general interest as well. And it is from the conclusions of this research that I am basing my talk today. The report is available on the Europa website if you want to read it in greater detail. The main concern that came from the conclusions is that national judges in adapting and applying EU law worry most about time. The time to hear a case, to understand the law, to get a feeling of what EU law should apply is very important. But also the time to study and to keep up as well. And therefore, my message from this talk is that I think it's very important to think about a sustainable personal training program for individual judges. Judges comment that when they go to the intensive training programs organized by the EJTN, they get a lot out of them. But then when they return home and they go back to work, it is very hard to sustain the momentum of keeping up with EU law. Judges also commented about loneliness, a feeling that they are very alone in applying a new kind of law. And there is the need to share experiences of handling cases in new areas of law. Another common factor is the need for linguistic training. EU law is very new, and many EU law terms are also new. They are often an amalgamation of different foreign terms. One clear example that I could give you is in competition law. Under Article 102 of the TFEU, there is an abuse of a dominant position. And each word has a very specific meaning and context. That meaning and context comes from European Commission decisions, it comes from the European Court's case law, but also an understanding in national law as well. And yet for the English ear, abuse of a dominant position is not a term everyday people would be familiar with. So each word has its own specific context and meaning.
I think we have a problem with connection.
It's common knowledge that EU ECJHR case law and CJ case law are quite different, and I believe that the European Court of Justice judgment on the European Union joining the European Convention on Human Rights was the main prerequisite for not joining of the EU to the convention so far. If we look at the Charter of Fundamental Rights in terms of application of criminal sanctions, we'll see that it somehow is similar to the way the European Convention sees the application of criminal sanctions. I believe we have all doctrinal grounds to approximate Ukrainian legislation to European legislation. I have another question to the participants. ECTHR judgments contains paragraphs where the court interprets international standards in a very widely manner. The recent case, Branner versus Germany, and the matter of the case consisted in the following: whether the operator was entitled to collect personal data if the customer purchases prepaid services rather than signs a contract, and the ECTHR when answering to the fundamental question whether such practice corresponds to Article 8 of European Convention. If the similar case is considered by the Supreme Court of Ukraine, do you think it could be guided by the respective case law of ECTHR with proper consideration of the rules of EU law? I will now give floor back to Erika Shishak.
You're on the screen,
just back.
Yeah. I was talking about the difficulty of judges having to interpret the uncertainty of EU law into their national legal system of the foreign concepts, but also in many areas today, particularly competition law, the European Commission makes day-to-day policy through the forms of soft law, which are not so easily available or so easy to understand. So finding EU law and keeping up with developments is a challenge for judges, especially keeping up with the case law of the European courts. And of course, the Europa site is very useful, and there are very many blogs nowadays, particularly also blogs from professional firms of solicitors and accountants. But it is a question for judges of where to find the time to do all of this reading. As EU law becomes more important in Ukrainian courts, national judges will need a comprehensive program of information and seminars to keep up to date with developments. And I think the demand will be driven by more non-state litigants using EU law to further claims in the national courts. For example, private litigants, consumers, competitors, non-governmental organizations, interest groups, for example, consumer groups. Many years ago, in 1974, a very famous English judge, Lord Denning, described the process of EU law as invading English law. He said it was like an incoming tide. It flows into the estuaries and up the rivers. It cannot be held back. And this may be the case in Ukraine. The Danube, the Dnieper, the Dniester may carry litigation that cuts across traditional national divisions of law. For example, a claim may involve competition law, data protection law, consumer law, human rights. It may also raise issues about legal interest, whether the litigant has standing to bring the claim, procedure, and also efficacy of remedies. So Ukrainian judges have a lot to contend with. And today, with global social media, it may be very difficult to resist the opportunity for litigants to use the political space of EU law to challenge laws, policies, and behavior that causes harm, or even to challenge and change Ukrainian laws that they do not like. I thought I would give you a very recent case from Romania to show the challenges that are faced by national judges, but also differences of approach between a Court of Appeal and the Supreme Court, and also the fact that this litigation involved not only substantive law, but also the application of the general principles of law. The case is case 30819 Whiteland, and the ruling was given on the 21st of January 2021, last week. The facts of the case concern a decision of the Romanian National Competition Authority in 2015. And the Competition Authority found that Whiteland, an import-export company active in food distribution, had infringed Article 101 of the TFEU. This is the provision which deals with cartels. And also the national Romanian competition law was infringed as well. And so the Competition Authority imposed a fine. However, the cartel infringement had ended in July 2009. And Romanian law, the official opening of an investigation interrupted the 5-year limitation period for the Competition Authority to bring the case. And therefore, the normal 5-year limitation period had ended in September 2014, whereas the Competition Authority had taken until April 2015 to take a decision. So it had taken 1 year after the end of the limitation period. The Bucharest Court of Appeal agreed with the complainant, Whiteland, that the investigation had taken too long, and therefore the infringement was time-barred. However, the Competition Authority appealed, arguing that if one took this approach, it would jeopardize the uniform and effective application of EU law. Once an investigation has started, the limitation period should be suspended. The Court of Appeal takes a very rigid, formalistic approach. A Portuguese commentator, Miguel Sousa Ferro, says the Court of Appeal was getting drunk on cold water. The Court of Appeal decision was then appealed to the Romanian Supreme Court. And as Tatiana Komarova mentioned earlier, the Romanian Supreme Court was able to take advantage of the preliminary reference procedure to ask questions of interpretation from the European Court of Justice. And this, unfortunately, is not a tool which Ukrainian courts can use. And therefore, Ukrainian judges are very reliant on the received case law of reading these preliminary rulings after they have been given. So one of the questions that was asked of the Romanian Supreme Court was whether member states can be totally free in determining their limitation periods. Because normally in European law thinking, there is very little intervention at the national level of procedural rules. We talk about national procedural autonomy. And normally the member states can use their national legal systems to apply EU law. So if this was the case, could the national law allow for interruption of limitation periods if investigations took too long? Now, at this time, there was no European Union law governing limitation periods in competition law, but subsequently, with the ECN2 directive, we do now have some EU rules. But at this time, there was no European law governing the case. But the European Court of Justice did not stop there. It did not stop and say, well, yes, there is no European law governing this, therefore Romanian law can take precedence and do what it likes. Instead, the European Court of Justice resorted to the EU principles of effectiveness and sincere cooperation. These are these kind of free-floating general principles of EU law, which occasionally the European Court of Justice decides to use. And it applied them to limitation periods for the enforcement of EU law. And what the European Court of Justice said was that even though the EU system has a decentralized system of enforcement of Articles 101 and 102, the member states cannot be entirely free to frustrate the enforcement of EU competition law. But if they imposed rules, limitation rules or time barring rules, which made it impossible for investigations to be duly carried out by the national competition authorities, this would hinder the application of EU law. So therefore, if more time was needed, more time should be granted. And knowing whether or not more time was needed could only be determined on a case-by-case basis. So the court noted that even in the absence of EU harmonization rules on limitation periods, the member states must ensure that the competition authorities are empowered to apply Articles 101 and Articles 102. And the member states must do this in compliance with EU law, particularly the principle of effectiveness. And they must take into account the very special nature of competition law. The court then goes on to say that national rules cannot make it impossible or excessively difficult to enforce EU law. And they must ensure that the effectiveness of the uniform application of the EU law is not jeopardized. So it's okay at the national level to have reasonable limitation periods. These are necessary for legal certainty, but there must be a balance between the conflicting interests. And to assess whether or not this balance, this equilibrium has been duly achieved, one must consider the national regime as a whole and the specificities and degree of the complexity of the specific cases. So time barring rules cannot systematically exclude the application of EU law here. So this again is another duty for the national judge of not having to apply the national law and EU law, but also to use the judge's discretion to see whether or not the overarching ideas of the effectiveness of EU law are placed in jeopardy if the national rules are being applied. And if an interpretation in accordance with EU law is not possible, then the national law must be set aside by the national court. Now, the Court of Justice, as you know, is very discreet when it's dealing with national courts and national judges. The court did not declare the Romanian law to be incompatible with EU law. It said it was for the national judge to decide this. But if the national judge believed the interpretation of Romanian law is not possible, then it must interpret the rule differently. And in this case, the Romanian Supreme Court must interpret the national rule differently from the Court of Appeal. So this case confirms a lot of the European Court's case law. There is the Fleiderer and the Vedic judgments that all and any procedural rules set out in national law must not deprive the provisions of EU law of their effectiveness and must also be interpreted in a way which ensures the effectiveness of EU law. So this is a very good example of a national Supreme Court identifying a problem of compatibility with EU law. But the problem is a very deep problem here, because it was not a problem of an incompatibility with a written or a substantive law. It was how to apply the general principles of law, national rules. So this reach and surprise of the penetration of EU law into national law has been called a jack in the box. I think you know the little toy that children have where you press down the lid and suddenly it jumps up and it surprises you. Children's surprise toy, an EU law-based claim, can pop up any time in the Ukrainian judicial system. So, as well as the training aspect for individual judges, there is a need for the constant monitoring of Ukrainian legislation to ensure compatibility with EU law. But also, I think, a process to manage case files, to avoid the judiciary and the courts from being overwhelmed by many cases. But there must also be space for judges to study and reflect and to share their experiences as well. I was very surprised when I did the research for the Commission on Judicial Training, because I discovered that the Portuguese competition law judges had their own private Facebook page. And I've never known judges have a Facebook page. It's very unusual for me to learn. And on this page, the judges in a private, safe space could share their experiences, their problems, their views. They could gain knowledge, but also they could support each other as well, that they gain support from their peers. I'm not saying Ukrainian judges should join Facebook because there are problems with Facebook as well. But Portugal is interesting because it's a small country. You can have perhaps peer group support, but it also is a country which is, I can't say suffering, but it's experiencing a lot of private damages claims brought by individuals. Just the very last point. Yeah. Yeah, okay. That really is my last point that I want to make, that, you know, Portugal is a small country. It might not work for Ukraine, but there is perhaps the need for support of judges in dealing with what is a very new legal system, new problems, and also the danger of being overwhelmed. Because this is the very last session, I thought perhaps we could do a yoga session. But my last point is that maybe judges could take time to pause and think about their own training needs and how to keep their training needs sustainable. Thank you, and I'm really sorry for the problems with the internet this afternoon. Thank you.
Thank you so much, dear Professor, for your presentation. And a small remark on our side, when we speak about Facebook groups of Ukrainian judges, I think that Ukraine is really the country where there are so many groups on Facebook, Telegram, WhatsApp, Viber. Ukrainian judges and Ukrainian lawyers are very eager to use social networks in professional capacity as well, for professional discussions of different important topics. I think that dear Professor Erika was our last speaker for today. We still have a chance for discussion, but to moderate this discussion, I will give the floor to Rasim. It will be better. Thank you, Anna. I see that we have had some questions before. They were almost all covered. And based on results of the discussion, we see that more or less we have a consensus that it is necessary to ensure reception of legal approaches to EU law and ECJ decisions in in Ukrainian system. And such conclusion is that we have difficulties in reaching it, and the challenges are language barrier as to accessibility of judgments. But again, this issue is can be really circumspected, and we have some good overviews of decisions. I call on participants and on those who have a chance in chat or in private, in personal capacity, give your remarks. So if you want, write something on the chat. Who wants? What are your wishes? Dear colleagues, if I may, I'd like to say a few words. I want to thank for the information that I and judges got today. And I liked so much. I guess it was Tatiana's remark that we cannot miss this situation, that courts will just quote without any thinking, quoting of EU judgments, ECJ judgments, because we know that we don't have a very good situation with ECTHR decisions. Sometimes quotes are just copy pasted from one decision to another without analyzing respective positions and without due regard to circumstances of its conclusion and against what country it was surrendered and what legislation was analyzed. And of course, we aim not to see the similar situation with ECJ. And it was a wonderful proposal on the chat of my colleague, as far as I understand, from Civil Cassation Court, that it is necessary to pay attention to training of judges and to ensure methodological reference materials, because judges have difficult time to understand what is what as to EU law sources and how they can be used and how they should be used when substantiating decisions of national courts. Again, thank you so much. Thank you, Mr. Vitali. We have such national peculiarity. We do need some sort of standard of relevance in these issues within the context of ECTHR case law were worked, and they will be very relevant to be used by ECJ. Even maybe it will be even more difficult.
Um, However, we need to understand that some fragmented quotes of the Court of Justice case law is not acceptable, and it's something that needs to be articulated and made clear for everybody from the very beginning. Are there any other comments or questions? Rasim, if I may. In response to Vitali's comment, as a representative of academia circles, together with my colleagues, we are ready to support such approach, and Ukrainian academic circles are also ready to provide all support to practitioners in terms of interpretation of European law and ways of application of European law in national courts. And if we make comparison with Poland, I think Anna will confirm it. Despite massive preparatory work which had been held in Poland before joining the European Union, there were so many difficulties experienced by Polish judges and public administrations. In the field of proper application of European law. becoming part of the European community is a time consuming and effort consuming process. So many texts need to be translated into the national language. So many pieces of legislation need to be implemented into the national legal system. And by the way, speaking about approximation of legal systems and implementation, if EU law into national legislation, as a rule, courts of lower instances are more proactive in comparison to Supreme Courts, and it's first and second instance courts which tend to apply before the Court of Justice of European Union with preliminary requests, just because their position is more proactive. Thank you, Tatiana. Indeed, I fully agree with what you said, and it's true that the majority of preliminary requests before the Court of Justice of European Union were prepared by Polish lower instance courts. It's because preliminary requests serve to the address of very specific issues which are of interest for usually claimants. Parties to a case. I also have a very short comment. Maybe the first instance courts apply with preliminary requests more often in comparison with the Supreme Court, just because they are the first ones to face cases where preliminary requests are needed. They are on the front line, if I may put it so. I would want to comment, if I may. So again, I go back in time to the first conference held last year in the premises of the Supreme Court. And you may remember we had a speaker from Germany there, and she was intervening on the preliminary requests sent by German courts. I had an opportunity to talk to her privately. We discussed her practice, cases she has been trying, and she said the following: 10 years ago, a national German judge was reluctant towards everything which was about European law. It was so 10 to 15 years ago. So German judges were just reluctant to apply or to make references to European law. But the things evolved extremely quickly. And now one can hardly find a court decision in the whole of Germany which would not contain any reference to the EU legislation. So things evolve. Things do evolve. I also partly agree with the remark of Rasim, who said that first instance courts may seem to be more proactive just because they are on the front line and because they are the first to accept and try cases which may engage European legislation. Supreme Courts usually act as instances where responses to preliminary requests are summarized and somehow how formalized Supreme Courts tend to come up with some generalized rulings or summaries on the EU application to be used by national courts of lower instances. At the end of my remark, I cannot but say what a pleasure is to participate in this event. I'm very happy with the fact that the issue of application of EU law becomes more and more widely discussed in Ukraine. Today we've heard some very specific examples from various um, areas, from various areas of law, from various jurisdictions. I welcome this huge step forward, bond forward, and I'm happy that we are applying efforts in order to ensure proper, let me underline it, proper application of the EU case law. Thank you, Ksenia. We have several comments confirming that the conference gives a perfect platform for discussion. In chat, we may see a vivid discussion happening between Mikhailo Smokovich and Tatiana Komarova. The discussion covers the will of Ukrainian judges to apply, and will and readiness of Ukrainian judges to apply European rules in Ukrainian jurisprudence. Dear colleagues, we have more time for discussion. Mr. Pushkar, please. In the context of application of case law of European Court of Justice, I believe that at this stage we may stand on the position of distance comparative approach, which means that Ukrainian judges may look at European Court of Justice case law and pick up some interesting ideas and approaches to interpretation to be applied in Ukrainian jurisprudence. Rossi mentioned today European consensus on certain matters. In some cases, the court would look at the availability of European consensus on certain matters. It's a very complicated issue, though, and I think that there is some one more thing to mention here. In many European countries, appellate instance is not available in certain cases, which means that national remedies are exhausted at the level of first instance, and in case of the necessity to go before the ECTHR, the case goes directly to ECTHR, and if there is a necessity to make a preliminary request to the Court of Justice of the European Union. Naturally, it's only the first instance court which is in the position to make such a request, just because a case would not go further to the Court of Appeal or the Supreme Court. Thank you, Pavlo. I'm now given floor to Anna Adamska-Galant for closing remarks for today. However, I'm very pleased to remind that it's the first day of a conference which is coming to an end, and tomorrow we will have an opportunity to enjoy the second part of the conference with no less interesting interventions from international speakers. The interest and topicality of the discussion can be confirmed by the number of messages in chat. Another floor is yours. Thank you, Rasim. Thank you for moderation. I'm very grateful to the speakers for being so active, for having prepared such interesting interventions. Our today's event proves that the online format is no way hindrance to effective discussion. Tomorrow we will have mostly foreign speakers from Poland, from Hungary, from so-called recent members of the European Union who have much to share from their own experience. I'm of course very pleased to see Ukrainian professionals and experts in EU law. It's a great contribution to the discussion. Besides, in the context of our today's topic, I cannot but mention something that one of the previous speakers mentioned. Ukrainian judges need to learn English because, of course, translations will come up at some and become available at some moment in time. But in order to have access to EU law sources, it's very practical to know English. This is it for today. Very grateful and see you all tomorrow.